Welcome to the New Books Network.
Welcome back to New Books in the American West, a channel on the New Books Network of podcasts. I am Stephen Hausman, and I'm your host for this interview. And today, I'm speaking with Wesley Phelps. Dr. Phelps is an associate professor of history at the University of North Texas, and we'll be discussing his newest book, Before Lawrence v. Texas, The Making of a Queer Social Movement, which came out with the University of Texas Press just last year in 2023. Welcome to the New Books Network, Wes. Good to have you.
Thanks, Steve. It's good to be here.
Why don't we start, as we always do here on the New Books Network, by just hearing a little bit about who you are as an author. I'm curious about your background, and in particular, I'm interested in what got you interested in history in the first place.
Okay, well, I may have had a somewhat unusual journey to history. I was not a history major as an undergraduate. In fact, I was an undergraduate here at the University of North Texas, so it's really cool to be back here teaching at my alma mater. I was a psychology major, and it wasn't until the very end of my college career that I got interested in history. In fact, I had a job working in the basement of the library here at UNT, and my boss at the time had a master's degree in history, was very interested in history, and most of the hours that I worked at that job were spent talking to him about history. And so by the time I was a senior, I had discovered this love of history, but it was a little too late to change my major, and I don't think I would have known what to do with the history degree. As it turns out, I graduated with a psychology degree and didn't know what to do with that either. So I worked a few kind of, terrible jobs for a few years after graduating. And then I decided, well, maybe I'll go back to graduate school and get a master's degree, and maybe I'll teach or something. But I had very little direction and very little mentoring at that time either. So I came back here to UNT to work on a master's degree. And while I was here, I had a couple of professors who they turned out to be excellent mentors. And a couple of them said, you have a talent for this. You should think about applying to a PhD program somewhere and become a professional historian. And at the time, I didn't really even know what that was. So they explained to me what a professional historian does. And I thought, yeah, that sounds really interesting, like going into archives, getting my hands dirty with actual sources, writing, teaching. All of that sounded really good to me. So I applied to some graduate schools. I ended up going to Rice University in Houston to work with John Bowles and Alan Matisow. Sort of really fell in love with the work that historians do over that time. It really took that experience to show me how much I really love doing this. So a little bit of a interesting journey, I think, for me anyway.
And what brought you to the topic of this book in particular?
Yeah, I wrote my first book that came out in 2014 about Lyndon Johnson's war on poverty during the 1960s, and specifically how it was implemented in the city of Houston. And I'm really trained as a social and political historian. And when I was conducting research for that dissertation, which eventually became the first book, I came across this story about a Houston mayor named Louis Welch. He was mayor for pretty much the entire run of my first book, from 64 to 74. But he came back in the mid-1980s to run for mayor again. And he had one of these kind of hot mic moments where, they were out on location with the TV news crews, and they were about to cut to his interview. And they cut to him early, and he didn't know that they had cut to his interview. And so this was at the height of the AIDS crisis in Houston in the mid-1980s and in the country. And so someone off camera had sort of asked him if he could remember all of the points of his plan to combat the AIDS crisis in Houston. And he kind of joked that he couldn't really remember what some of them were. He had to write them down. And about that time, the news coverage went live to his location, and he said, but I do remember the first point of my plan, and that's to shoot all the queers. And that just kind of stuck with me. I thought, this is really interesting. I'm trying to research for a dissertation. I don't have time to pursue this kind of story that happened much later. But at some point, I want to go back to that and figure out what happened. Like, what was that campaign all about? What kind of prompted this kind of anti-queer statement about the AIDS crisis. So once that book came out in 2014, I did return to that story. And what I found is that Louis Welch uttered that phrase in the midst of a very contentious debate in the city of Houston about a non-discrimination ordinance that the city council had approved that would have protected the rights of gay and lesbian workers in municipal government. And so there was a lot of anti-queer rhetoric in that campaign. And so I ended up writing an article that was published in 2018 about that, about the fight over the non-discrimination ordinance in Houston that was published in the Journal of Southern History. And one of the questions that remained with me after conducting that research was, why was it at this moment that gay and lesbian activists decided to try to get the city council to pass this non-discrimination ordinance? Was there something happening at the time that made them think that was an achievable goal? And what I found was that a federal district judge in Dallas, just a few years before that, had invalidated the state sodomy law. And his ruling was in effect from 1982 to 1985. So this meant for 3 years, there was no law criminalizing the sexual behavior of gay and lesbian Texans. And this seemed to me like an interesting explanation for why this particular window seemed like an opportune moment to push for other rights for queer Texans. So I started looking into this case, and then I realized there were a lot of cases, a lot of legal cases that dealt with the Texas sodomy law that came before the big one, which was, of course, Lawrence v. Texas. So I read Dale Carpenter's book called Flagrant Conduct about Lawrence v. Texas, which is an excellent book. And I decided we need something about the prehistory of this case. We need to know about the long history of anti-sodomy law activism in Texas. And that sort of gave birth to this book.
Well, let's start with kind of the end point here. Tell us just a little bit, kind of a thumbnail sketch of Lawrence v. Texas. What was that case, and why was it such a landmark achievement in the early 21st century?
Yeah, Lawrence v. Texas is a hugely important case in Supreme Court history and in the movement for LGBTQ equality. So Lawrence v. Texas came out of Houston. In 1998, John Lawrence and Tyrone Garner were arrested just outside of Houston by Harris County Sheriff's deputies for allegedly violating the state sodomy law, which was known as 2106, the homosexual conduct law. This law made it illegal to engage in oral or anal sex with a member of the same sex. And so John Lawrence and Tyrone Garner were arrested. They were charged with violating this law. Eventually, once their case kind of becomes known to local gay and lesbian activists in Houston, some national organizations get involved, like Lambda Legal, to kind of take this case and use it as an avenue to challenge the constitutionality of the homosexual conduct law. And of course, that eventually made its way up to the Supreme Court in 2003. And in 2003, the Supreme Court ruled that the Texas sodomy law and laws like it in 12 additional states violated the privacy protections of the U.S. Constitution. So those privacy protections that go all the way back to the birth control decision in Griswold v. Connecticut, and of course in the abortion rights decision in Roe v. Wade, that those kinds of privacy rights also applied to individuals who want to make private decisions about their intimate and romantic lives. And Justice Anthony Kennedy wrote a very eloquent and at times poetic defense of those privacy rights and how they apply to gay and lesbian Americans. The importance of that case is that it laid the groundwork for virtually all of the advances in the movement for queer equality that we can think of since 2003. So if you think about the congressional repeal of the military policy of don't ask, don't tell, for example, don't ask, don't tell had been a policy approved in the 1990s that allowed gays and lesbians to serve in the military only if they remained in the closet. And so the repeal of Don't Ask, Don't Tell allowed gays and lesbians to serve openly in the military for the first time in U.S. history. That would have been unthinkable had gays and lesbians still been considered criminals in Texas and 12 additional states. If you think about the partial nullification of the Defense of Marriage Act that had prohibited the federal government from recognizing same-sex marriages and extending federal benefits to same-sex spouses, even in states that had legalized same-sex marriage, that could not have happened had gays and lesbians still been considered criminals in 13 states. If you think about the Obergefell v. Hodges decision in 2015, that's the marriage equality decision. That would have been unthinkable had gays and lesbians still worn that stigma of criminality that had plagued them because of sodomy laws like Texas's homosexual conduct law. If you think about the Bostock v. Clayton County decision in 2020 that extended Title VII employment protections to gay, lesbian, and transgender workers all over the country, that would have been, again, impossible to imagine had gays and lesbians still been considered criminals in 13 states. So, as I say, Lawrence v. Texas is a monumental case that opened the doors to almost all of these more recent advances in the struggle for queer equality.
But of course, Lawrence v. Texas is kind of the end point of this book, right? And you're telling the story about kind of how we got to that point in Texas. So let's go back to where this narrative actually kind of begins in the story that you tell here. And you begin with actually a separate legal case, and one that, I guess, just speaking for myself, I had certainly never heard of before, some 40 years earlier. Can you talk a bit about the importance of the Buchanan v. Batchelor decision? Even though, as you say in the book, the litigation was, in your words, disorganized, poorly funded, and ultimately unsuccessful, it's still this kind of really important moment in the story that you tell.
Buchanan v. Batchelor was one of the big surprises as I was conducting research for this book. So what I wanted to do is kind of figure out, where did Lawrence v. Texas come from? In other words, did it just come out of nowhere, or were there cases that came before? And so I had discovered one case when I was working on that article about Houston. But I started looking back further, and I wanted to see how far back I could go. Now, I found challenges to the sodomy law in Texas going all the way back to the mid-19th century. The first one I found was actually in 1867. Those were not really constitutional challenges. So I thought, well, it'd be better to start with the first constitutional challenge to the Texas sodomy law. And that turned out to be Buchanan v. Batchelor, which, again, was a big surprise about how early it was, but also the details of that case. So Alvin Buchanan was a working-class guy living in the Dallas area at the time. It's unclear how he identified publicly. It's unclear if he ever identified as a gay man, but he did engage in sexual activities with other men. And in 1969, he got arrested a couple of times, and both of these times were in public or quasi-public places. So the first time he was arrested, it was at a public park in Dallas, a park called Reverchon Park, that was kind of known as a gay cruising spot. He was arrested there for engaging in oral sex with another man. A few months later, he was arrested at the Sears department store downtown, at the public restrooms in the Sears department store. Again, also somewhat of a known cruising area for gay men in the late 1960s. He was arrested again there. He was charged with violating the previous version of the Texas sodomy law. So before the homosexual conduct law, before 2106, Texas had a law called Article 524. And Article 524 made it illegal for anyone in the state to engage in oral or anal sex with anyone else. So this would include same-sex partners, opposite-sex partners, single people, married people. Everyone in the state was prohibited from engaging in that kind of sexual activity. So Alvin Buchanan was charged with violating Article 524 and was about to go to trial when there was a young attorney named Henry McCluskey Jr., who had just recently graduated from Baylor University Law School, just kind of starting out his career in the Dallas area. And he was a gay man and was out at least to his closest friends. And he was looking for a way to kind of use his legal skills and his legal know-how to generate a gay rights movement in Dallas, to try to use the legal system to push for queer equality in Dallas. And he was actually very good friends with a woman named Linda Coffey. And Linda Coffey was an attorney. She was the first attorney for Norma McCorvey, who became Jane Roe in the Roe v. Wade case, in the big abortion rights case. And so Coffey is, of course, thinking a lot about privacy rights and how the constitutional right to privacy could protect women who were seeking abortions in states where abortion was illegal. And so when Henry McCluskey heard about Alvin Buchanan's arrest, he started thinking in terms of, how could I use the constitutional right to privacy to defend someone like Alvin Buchanan? So he contacted Alvin Buchanan and said, I want to be your attorney. I want to use your case to try to challenge the legitimacy of Article 524. And so Alvin Buchanan agreed. So when Alvin Buchanan was convicted, he appealed that conviction up to a district court in Dallas. That was his case eventually went before a 3-judge panel before this particular court, and that court ruled that the Texas sodomy law, Article 524, was indeed unconstitutional. It did violate the Constitution, but not because of how it affected Alvin Buchanan, but rather because of how it affected married couples in the state of Texas. So the ruling came down that because Article 524 invaded the privacy rights of married couples in Texas, the entire law was unconstitutional. So this decision struck down Article 524, but not for the best reason, right? Not for the reason that attorney Henry McCluskey or Alvin Buchanan were kind of hoping for. And in fact, Alvin Buchanan's case was then sent back down to the lower court, and they simply he was ultimately convicted because of the public kind of nature of where he was arrested, although that was also in dispute during Buchanan v. Batchelor. So even though this was kind of disorganized, as I say, poorly funded, ultimately it was unsuccessful for Alvin Buchanan, it did lay the groundwork for using the Constitution to advance the rights of queer Texans.
You spent some time in the book also talking about the kind of on-the-ground lived reality for LGBTQ individuals in Texas at this time. So can you describe this a bit? What were the kind of practical effects of Texas's homosexual conduct laws as they existed at the time?
Well, there were many consequences of this law. So this new law, 2106, the homosexual conduct law, the state legislature approved it in 1973 during a major rewrite of the penal code for the state of Texas, and then it took effect in January of 1974. As I said, this law made it illegal to engage in oral or anal sex only if you engaged in that conduct with a member of the same sex. So while the previous sodomy law, Article 524, had applied to everyone, this new law, 2106, was targeted directly at gay and lesbian Texans and anyone who engaged in sexual activity with a member of the same sex, whether they identified as gay or lesbian or not. When I first started researching this, I was curious how many people were actually being arrested for violating this law. And I think the conventional wisdom, at least at the time, was there were very few arrests. So people were not, the police were not banging down the doors of people's bedrooms and arresting them for violating 2106, the homosexual conduct law. Although in 1998, that's exactly what happened to John Lawrence and Tyrone Garner, setting up Lawrence v. Texas. But that was sort of an outlier. For the most part, police weren't doing that. Now, I say that with just a little bit of hesitation because we don't know that for certain. Because if a conviction is not appealed in the state of Texas at the criminal level, we don't really have a record of it. And most people who were arrested and charged with violating the homosexual conduct law, they wanted to quietly pay the fine, perhaps get on some sort of deferred adjudication. So after a certain number of months, it would be wiped from their record, and they just generally wanted to keep it quiet. So we really don't know how many people were being arrested for violating this law, but the conventional wisdom suggests that it wasn't a lot of people. So how did this law affect the lives of gays and lesbians? Well, its mere existence in the criminal code of the state of Texas marked gays and lesbians as criminals. In other words, they didn't have to be proven to be criminals. They were already assumed to be criminals in the penal code. So this could mean a range of discrimination in a lot of different ways. For example, employers could refuse to hire someone simply because they were gay or lesbian. Steve Childers found this out when he applied to work in the evidence room at the Dallas Police Department. And when the hiring officials at DPD found out that he was an official with the local gay and lesbian church in Dallas, they refused to hire him. And they didn't come up with another reason why they weren't hiring him. They could just say, you are an admitted criminal. By being an openly gay man, you admit that you violate the penal code of the state of Texas, and we can't hire criminals. That could happen anywhere. There was people who were fired from their jobs simply because they were gay, and the rationale was, we don't hire criminals here at this place of business. There's another example of a woman named Mary Jo Risher who had the custody of her children revoked when her ex-husband found out that she was lesbian and living with her partner. The ex-husband got the court to revisit the case, and in the aftermath of that, her custody rights were taken away from her for her 9-year-old son. And again, the rationale there was this person is an admitted criminal. You could be denied housing because you were an admitted criminal, right? Because if I'm selling a home to someone or if I'm renting a home to someone, I am not required to sell or rent to someone who is an admitted criminal. There were cases where gay men and lesbians were denied public assistance because they were admitted criminals in the eyes of those public officials. There was rampant police harassment. Police would often raid gay and lesbian establishments and harass gay and lesbian people in neighborhoods all over the state of Texas. And often they didn't come up with some other reason. They said, because homosexual activity is illegal in the state of Texas, we are simply doing our job and prosecuting criminals when we're supposed to. So for all of these reasons, and there are plenty more, right, the homosexual conduct law, even if people weren't being arrested and charged with violating it, it served as a justification for discrimination against them. It rendered them second-class citizens in Texas and in other states with laws like it.
But of course, people didn't necessarily just kind of accept this as a reality and as the way it had to be. People organized and people resisted. So in response to this law and all the impacts that you just kind of delineated there, how did Texans react? How did people protest? How did people fight back against these laws in the 1970s and 1980s? What forms of protest did it take?
During the 1970s, before there was really an organized effort to challenge the sodomy law itself, there were some actions that gays and lesbians in Texas took to try to combat this. So one example in Houston, the gay and lesbian neighborhood in Houston is known as Montrose. Gay and lesbian activists there created what was known as the Montrose Patrol. And it was really designed to do two things. One, it was designed to cut down on crime in the area. So, often there were crimes committed against gays and lesbians in Montrose that were clearly motivated by people who wanted to come down and commit acts of violence against openly gay and lesbian people. So one purpose of the Montrose Patrol was to, in the absence of adequate police protection, they stepped in to help protect people in Montrose. But the other purpose of the Montrose Patrol was to patrol the police, right? To keep an eye on the police in much the same way that the Black Panthers did in the Bay Area when they got started in the 1960s, to just kind of keep an eye on the police and to document and report instances of police harassment and police aggression. That was then picked up in Dallas, and there was a patrol that was started in Dallas. There were other ways of kind of resisting this. In San Antonio, there was an activist named Gene Elder who, San Antonio is a military town. There are a lot of military bases there. And what they noticed was that there were a lot of military police coming into gay and lesbian bars in San Antonio and harassing patrons. And they claimed it was because they were there to make sure there were no soldiers who had come in there and were, cavorting with criminals. And so Gene Elder really got a group together to fight against that, and eventually got a promise from military officials that they wouldn't come in uninvited to those gay and lesbian establishments anymore. There were efforts to kind of rally around people who had been fired from their jobs, to try to get them their jobs back. There's a story that I tell in the book about a hotel employee in Fort Worth who was fired for being gay, and some local gay activists kind of helped him raise a big issue about it. And they ended up taking him back on as an employee. So during the 1970s, there are these kind of sporadic efforts to combat the effects of the homosexual conduct law, but it wasn't really until the mid-1970s that activists decided, okay, we need to target the very thing that is justifying all of this discrimination against us. We need to launch legal challenges against the sodomy law itself.
Right. And in the 1970s and 1980s, in the book, you describe a whole array of legal challenges against the law. So what are the implications of these challenges? Even if they kind of fail to overturn the law itself, they have these kind of important after effects nonetheless.
They absolutely did. One of them, of course, was that they laid the legal groundwork for the eventual success in Lawrence v. Texas. So they were sort of laboratories for figuring out how to use the Constitution to argue that the state sodomy law was unconstitutional. And they tried a lot of things. I'll give you one example. In a case that was filed in 1979 known as Baker v. Wade, they tried to use the constitutional right to privacy. They also used the 14th Amendment protection for equal protection. They also tried to make a First Amendment case against establishment of religion, claiming that the sodomy law was based on this kind of Judeo-Christian moral code, and that violated the First Amendment prohibitions on an established religion. So they're really trying a lot of different constitutional arguments. And that, as I said, served as this laboratory. So by the time we get to Lawrence v. Texas, gay and lesbian activists knew what worked and what didn't at the federal level. But that's just kind of one impact of these early cases. Another one was it helped to educate more people about the discriminatory effects of the law. A lot of people at the time had no idea there was even a prohibition against, this kind of sexual activity in the Texas Penal Code. So by launching these cases, it allowed activists to travel around the state and educate people about how, just how discriminatory this law was. Don Baker, who was the plaintiff in Baker v. Wade, was an expert at doing this. Don Baker was a born educator. And throughout the years of his case, which spanned from 1979 to 1986, he traveled the state educating people about how this law justified discrimination against gay and lesbian Texans. And then third, it allowed for gay and lesbian organizations to kind of coalesce around a common cause and build strength by mobilizing and bringing new people into the movement. So these effects were, really important. As I mentioned, Baker v. Wade, there was a small gay and lesbian rights movement in Dallas during the late 1970s. But after launching Baker v. Wade in 1979, that movement really flourished as organizations like the Dallas Gay and Lesbian Alliance and the Texas Human Rights Foundation really just exploded in membership and in, of course, financial contributions, enabling them to continue on with these cases.
So this activism and this kind of flurry of legal challenges, they're occurring within the context of the emerging HIV and AIDS crisis in the 1970s and especially the 1980s. So I'm interested in how the AIDS crisis, how it is kind of shaping this activism in Texas during this period. How do these two things intersect and connect?
That was something I found really interesting in the research for this book because when Buchanan v. Batchelor happened, there was no AIDS crisis yet. And when Baker v. Wade was filed in 1979, there was no AIDS crisis yet. So at the beginning of that case, none of that really entered into the conversation. So Don Baker and his legal team were able to make, strictly constitutional arguments about the law. By the time they got their initial ruling in that case, it was 1982. And that was a favorable ruling. So in 1982, there was a Dallas district judge who ruled that 2106, the homosexual conduct law, did indeed violate federal constitutional protections of privacy and equal protection. And he struck down the state sodomy law and issued an injunction, meaning it could no longer be enforced. This was a huge victory, but as I said, that came in 1982, right when the AIDS crisis is starting to catch people's attention. So when the state of Texas appealed that decision to the Fifth Circuit Court of Appeals in New Orleans, they absolutely tried to make the AIDS crisis an issue. And what their argument was that as they saw it, HIV and AIDS, and HIV had not been identified just yet, but when it was, HIV and AIDS, they argued, was mostly the fault of gay men. And they were the ones who were spreading it to other people and putting non-gay people at risk. And so their justification for the sodomy law was, we are trying to prohibit the very type of sexual activity that leads to increased transmission of HIV and AIDS. In other words, by making anal sex illegal, we are protecting the public health of all Texans. Now, Don Baker and his legal team really struggled to come up with a response to that, mostly because there was just such little known about HIV and AIDS at the time, even about its transmission. Even as late as 1982 and 1983, there were still questions about how it was transmitted. Most medical professionals had reached a consensus that it was a disease that was spread not through close contact, but through bodily fluids, especially through sex and through blood, so blood and semen and breast milk. But there were still a lot of theories out there that maybe it was just casual contact that could spread it. And so what Baker's legal team argued was, this is irrelevant to this particular case. Because this evidence, these arguments about HIV and AIDS were not presented in the original trial, they can't be presented now. And for the most part, the Fifth Circuit Court of Appeals agreed with them on that. So most of the evidence that the state of Texas wanted to use to justify the law, they weren't able to use because the court said, right, this wasn't it clearly wasn't what the legislature was thinking in 1973 when it approved this law, and it wasn't entered into evidence in the original case in 1979. Now, regardless, the Fifth Circuit ended up overturning that previous decision and reinstating the homosexual conduct law, but not on the basis of public health, they ruled on the basis of morality, that the state of Texas has an interest in promoting morality in society, and therefore, if they want to pass a law prohibiting what they see as immoral sex, they're completely free to do so. So even though Don Baker and his legal team were able to keep this issue of HIV and AIDS out of that appeal, they ended up getting a ruling against them. By the time we get to the next case in 1989 in Morales v. Texas, more was known about HIV/AIDS, and it's really interesting that argument didn't come up very much in that case. Now, they had a much friendlier attorney general at the time. The attorney general was a guy named Dan Morales at the time. He didn't like this law anyway. He didn't think it was enforceable. He doubted the constitutionality of it. So he wasn't going to defend it as much as, say, a previous person like Henry Wade did in Baker v. Wade. He wasn't willing to go to the mat and try to defend this law in that way. Now, he did defend it because he was legally required to do so as Attorney General, but he never tried to use the AIDS issue, and it really doesn't come up in any of the other cases. And interestingly, never really came up in Lawrence v. Texas either.
The conclusion to this book is entitled Lawrence v. Texas Reconsidered. And I want to kind of focus on that last word for a second, reconsidered. And I'm curious how you think the story that you tell here, how is it pushing historians? In what way is it pushing historians to do just that, to reconsider this court ruling? And kind of connected to that, I'm wondering what you see as the kind of after effects to this story. What's the kind of legacy of Lawrence v. Texas? You mentioned that a bit ago, but I'm curious about how these questions of reconsidering this case and legacy are intertwined.
Well, I think a lot of people, if they know about Lawrence v. Texas or if they read about Lawrence v. Texas, they get the impression that it just kind of came out of nowhere, right? That there were these two guys who were arrested and charged with violating this unjust law, and they fought for their rights in court and eventually won, overturning this law. That it just sort of came out of nowhere, and that's what I want readers to reconsider about Lawrence v. Texas. I'm making the argument that this case did not come out of nowhere. In fact, there were decades of grassroots activism that made Lawrence v. Texas possible, and that we should pay attention to these earlier activists who helped do that, who helped lay that groundwork. So going all the way back to someone like Alvin Buchanan, someone who we don't really know that much about, someone like Henry McCluskey Jr., who, by the way, was murdered not very long after Buchanan versus Batchelor. We should know those names because they're important in this long history of gay and lesbian activism in the state of Texas, and they should be remembered for helping to achieve the victories that had these kind of national implications. We should remember people like Don Baker. Don Baker was a regular guy. I read a lot about him in the court records. He told this very deeply personal story about himself, how he knew that he was gay from a very young age, but he was raised in a very religious household and was terrified that he was, going to be condemned by his church, disowned by his parents, and that eventually he would burn in hell for being gay. He wasn't able to finally admit to himself that he was gay until he was well into his 20s. And when he came back to Dallas after finishing his college degree up in New York, he came back to Dallas, finally came to terms with his sexual orientation. He came out to his friends and his family. He started to get involved in local gay and lesbian activism in Dallas, but he was also a teacher, that's a very sensitive job to have at the time. So when the Texas Human Rights Foundation approached him in 1979, asking him if he would be their plaintiff in a case to challenge the constitutionality of the Texas sodomy law, he really put everything on the line to become that plaintiff because, it was going to be a very public role for him. And he accepted that willingly. Again, putting his life and livelihood at risk, putting his own safety at risk to do that. We should remember people like Don Baker. We should remember the individuals who were involved in an organization like the Texas Human Rights Foundation, attorneys like Mort Schwab in Houston, people like Mike England and Dick Peoples and Lee Taft here in Dallas, who helped put that case together. Jim Barber, who was the trial attorney they hired to be Don Baker's attorney and argue against the Texas sodomy law. Again, all these people are risking things to engage in this kind of activism. The next case that I talk about, in Morales v. Texas, we should know about people like Linda Morales, who filed suit against the Texas sodomy law in 1989. Ultimately, her case was also unsuccessful, but once again, she's laying the groundwork for the eventual success in Lawrence v. Texas. We should know the name of someone like Micah England. Micah grew up in Oklahoma. It was her childhood dream to become a police officer. She came from a family of law enforcement officers, and she dreamed of being a police officer. She was living in Tulsa. She was in her early 20s at the time. She was working at a restaurant. She hadn't been able to get a job as a police officer yet. And the Dallas Police Department held a recruiting fair up in Tulsa because they were so short. They had such a shortage of police officers in Dallas. And Micah went to that recruiting fair and said, "It's been my lifelong dream to be a police officer, but there's one problem. I'm a lesbian, and I hear that the Dallas Police Department doesn't hire openly gay people." This is in 1988. And the recruiter said, "Look, we are so desperate for officers right now, it won't matter. So just come on down, fill out the application, you'll get right in." So she did that. Now, she wasn't making a lot of money. She had to take all of her vacation time from the restaurant that she was working at, all of her savings, to come down to Dallas to spend a couple of days to apply for a job at the Dallas Police Department. So she did that. She came down here. She went down to the department to apply. And as she was filling out the application, she came across a question that asked her, "Have you ever committed a deviant sex act?" And she told me she thought about that for a minute, and she thought, "I guess they're talking about being a lesbian, so I better be honest about it." So she just wrote, "I'm a lesbian." Well, when the hiring officials read that, they said, "I'm sorry, there's no way we can consider your application, because if you admit to being a lesbian, then you admit to being a criminal in the state of Texas, because, gay sex is illegal." Micah was not willing to accept that. She is not the type of person just to pack up, go back to Tulsa, and forget about it. She walked down to a phone booth, pulled out the phone book that was attached to the phone book, and just looked up gay. That's all she knew to do. She looked up gay and came across the Dallas Gay and Lesbian Alliance. She called that phone number, and it just so happened that the president of the Dallas Gay and Lesbian Alliance, a guy named William Wayburn, was there that day answering the phone. And he answered the phone, and she was in tears and told him what had happened at the Dallas Police Department. Well, it just so happened that the Dallas Gay and Lesbian Alliance had been pushing the police department to change its policies for several years. So William said, "Wait right there. I'm coming there. I'm coming to you immediately." Went down there, picked up Micah England, brought her back to the Dallas Gay and Lesbian Alliance office, talked through what had just happened to her, and they decided, we're going to go to the city council meeting that's happening tonight, and we're going to get to the bottom of this. So they went to the city council meeting. Now, the way the city council meeting works in Dallas is you have to speak on the topic that is approved for that particular meeting. So the topic for that night was human rights in China. For some reason, the Dallas City Council was interested in human rights in China. So as they were walking in, Micah sees a poster on the wall for the Equal Employment Opportunity Commission. She took that poster off the wall and brought it into the meeting and signed up to be a speaker. And so when it was her turn to speak, she came up to the podium and she said, "I know the topic tonight is about human rights in China, but I want to talk about human rights a little closer to home right here in Dallas. Out here in the lobby, I just pulled off this poster that said the city of Dallas is an equal employment opportunity employer. That means everyone has a chance to get positions that they're qualified for. But I just applied for a position at the Dallas Police Department, and I was told that the only reason they can't hire me is because I'm a lesbian. And it was an extraordinarily moving and impassioned plea from her. Well, the Dallas City Council didn't really do anything about her complaint, so she filed a case against the Dallas Police Department. That went up through a circuit court. She got a favorable ruling from a circuit court saying not only that the policy was discriminatory, but that the sodomy law itself was unconstitutional. That went up to an appellate court, and an appellate court agreed. And so the only court standing left in Micah's way was the Texas Supreme Court. And the city of Dallas missed a filing deadline for their appeal. Now, Micah thinks that that was intentional. I haven't found any evidence that that was intentional, but what that meant was that ruling that the Dallas Police Department's policy was discriminatory and the sodomy law was unconstitutional, it could not have statewide effect. Because the only way to have statewide effect is if it goes up to the Supreme Court. So it was questionable where that kind of what jurisdiction that particular appellate court had, and does this actually apply to the city of Dallas? The police department didn't change its policy for quite some time, and as we know, the sodomy law wasn't overturned until 2003. Nevertheless, Micah, Linda Morales, Don Baker, Henry McCluskey, Alvin Buchanan, all of these individuals risked their lives and livelihoods to lay this legal groundwork that eventually gave us the victory in Lawrence v. Texas. And so if Lawrence v. Texas is as transformative as people argue that it is, and I think that it is, we need to see these previous cases as equally transformative. They're just as important for eventually bringing in this era of greater equality for LGBTQ Americans.
Yeah, I mean, that was kind of one of my big takeaways from this book is that, on the one hand, this is a book that it's about legal challenges and legal cases and that sort of thing. But those cases are, they're made up of people, right? That this is a book that is so much about, individual people and people coming together to challenge injustice. So that was my takeaway too, is that, you have to kind of focus on these stories as much as you do the kind of big landmark decisions as Lawrence v. Texas.
Yeah, I think that's right. I think we need to understand that when we think about these big landmark cases, there are real people behind them. Even a case like Lawrence v. Texas, a lot of people even today don't know a whole lot about John Lawrence and Tyrone Garner. As I mentioned, John Lawrence and Tyrone Garner were working class guys living on the outskirts of the city of Houston. John Lawrence was a medical technologist, sort of like a lab staff member at a local medical facility. Tyrone Garner often was unemployed. He often was didn't have a place to live. And so, these guys, when they were arrested, they're not plugged in to any kind of gay and lesbian rights organizations. They didn't consider themselves activists. It's unclear if they ever even really publicly identified themselves as gay men, at least in the case of John Lawrence. And so, their arrests and eventual linking up with gay activists in Houston, and then eventually national organizations, taking an interest in their case, that's a story that we need to know, because I think it's important to know that these cases don't just happen. They take real people, and I wanted to kind of uncover the humanity of those individuals and what they did for in the movement for queer equality.
So for my last question, Wes, I always like to get a preview when I can of what my guests have been working on since the book's release. So this book came out just about a year ago, and I'm interested in what you've been working on since. What sorts of projects do you have in the offing? Can we get some kind of preview about what you have coming down the line?
Well, the biggest project I engaged in after the publication of this book is a podcast series called Queering the Lone Star State. It is a narrative podcast series, so it's a documentary-style narrative podcast. It's 10 episodes, and in these episodes, we are chronicling the legal battle for queer equality in Texas. So each episode takes a single case, and in some cases, I'm able to dive a little more deeply into that case than I was able to do in the book. One of the great things about podcasting, I'm sure you know this, is you get to hear the voices of the actual participants. Mm-hmm. Right? So earlier I mentioned Mary Jo Risher, who had had her custody rights revoked because she was a lesbian. We talked to Mary Jo Risher. We allow Mary Jo Risher to tell her story. We talked to Linda Morales, who is the plaintiff in Morales v. Texas. So it allows me to go a little deeper on some of these cases. It allows people to hear the actual voices of the individuals who were involved. And then in some cases where I was able to explore legal cases that I wasn't able to talk about in the book, or at least maybe just a couple of sentences in the book, we're able to really look at them fully. So I encourage people to listen to that. It's available at queeringthelonestar.state.com, or it's on Apple Podcast and Spotify, or wherever people get their podcast. That was really the biggest project that I've worked on since the publication of the book. I have also, I just submitted an article about the case at Texas A&M during the 1970s. So I mentioned this case briefly in the book, but I wanted to explore it more. In the mid-1970s, gay and lesbian students at Texas A&M created an organization called Gay Student Services, and they applied to have their organization recognized by Texas A&M University. The university refused to recognize them, saying that, since gays and lesbians are criminals in the state of Texas, they could not recognize a group that would incite students to engage in criminal activity. The students had to take the university to court, and they eventually won on the basis of the First Amendment. So I'm making a slightly different argument in that article. Lately we have seen that many of these victories in the movement for queer equality seem to be under threat, especially with the recent Dobbs decision that overturned Roe v. Wade. Now, all of the other landmark cases that are based on a constitutional right to privacy seem to be in danger, including Lawrence v. Texas. And so I'm trying to make an argument in this article that perhaps we should revisit the First Amendment as a way to protect the rights of queer Americans. And perhaps this Texas A&M case will give us some insight into how the First Amendment could potentially be used in that way. And then finally, I'm at the very beginning stages of writing what I hope is going to be a cultural history of bisexuality. So I teach a course on U.S. LGBTQ history, and every time I teach it, I'm always looking for something to assign to students on bisexuality, and I just have never been able to find anything that's not either, so dense that they wouldn't read it. Right? There's some really good material out there on bisexuality, but it's so incredibly dense intellectual history, or it's not historical, right? It's kind of popular writing about bisexuality. So I'd like to write maybe a short, kind of 200-page cultural history of bisexuality where we look at different kind of cultural figures in the United States over the span of the 20th century to try to understand how Americans have thought about bisexuality, how they have defined it, how people have adopted that identity, and perhaps some of the conflict that has arisen from that within other queer communities who perhaps don't see bisexuality as a legitimate identity within the movement. I'm hoping to do something like that. But again, I'm at the very beginning stages of that.
Those all sound like fantastic projects, and I wish you luck in all of them.
Oh, thank you.
Dr. Wesley Phelps is an associate professor of history at the University of North Texas, and his new book is Before Lawrence v. Texas, The Making of a Queer Social Movement, which came out with the University of Texas Press last year in 2023. Thanks again so much for joining me today, Wes. It was a pleasure speaking with you.
Thanks, Steve. Really enjoyed it.